certificates of liability insurance are not always what they say they are, and you should get better proof of coverage between all of these entities. And I only say that because I have, how many now? 30.
Now, go ahead.
Well, so what does better proof of coverage look like?
So it looks like, I mean, what I prefer is I like for you to be an additional named insured under their policies. And you can now go on the WCIRB website, and they will tell you, all you need to do is put the employer's name in or federal tax ID number, and they will tell you if they are insured, and if so, who their workers' compensation carrier is. And I do that for anybody that I have that claims when they're working in my house. I will go on and make sure that they have, licensed and bonded. I love the licensed and bonded. They're licensed as an ice cream man, but they're doing roofing work. So I always double check to make sure. But we even had last year, 2 years ago, we had a case where the Accord form was produced as evidence of workers' compensation insurance, and the employer just openly admitted that he just took the form off the internet and signed it showing he had workers' compensation coverage. And there was no coverage. I mean, and he picked a carrier like Travelers or somebody else, and if you don't check it, you don't know. And that's more for personal than it is for business. Yes?
So this is what you would do for any third party coming in to do any contracted work in your place of business?
Yes, because you do not know.
Particularly in facilities and things like that?
Yeah. Yes.
Yes, because you don't know whether they actually have workers' compensation coverage, and if you bring in an unlicensed and uninsured entity, somehow you're going to be responsible for that.
You'll be the special, because the general and the special employer relationship is joint and several. So if one of you doesn't have coverage, the other one's left with it, and that's going to be you.
Yes.
So you're also saying, like you were talking about work being done around your house.
Oh, yeah.
Absolutely. I do not, and I have a little bit of a higher standard of care than you do, because I'm a lawyer and I'm charged with the knowledge of knowing this. But if I bring in an unlicensed, uninsured contractor, or I might even bring in, how about this? I bring a general contractor into my home, and I've proven he has a license and he's insured. But he brings in a subcontractor that is neither licensed or insured, and one of their employees gets injured. Well, if I haven't insured the general contractor's got comp, so if it turns out the general doesn't have comp, and the subcontractor doesn't have comp, guess who's going to pay?
His homeowner's insurance, who's no longer going to write him after that.
Well, yeah, your premium will go up significantly. And sometimes they don't pay, because sometimes there's a specific exclusion as to whether there's coverage. And then you've got yourself in all kinds of issues. Now, the reverse part of that is there are times in my legal career where I have actually argued that employee was my employer as a homeowner, because I want them to get workers' comp benefits. I don't want them to be able to sue me for general liability. So it really depends on the particular set of facts. But too many times people come into my office, and uninsured employers, and they come to my office and they say, but look, I've got his card. It says licensed, bonded, and insured. It's got a number that looks like, my social security number or something, but,
Or it's handwritten on the card.
Yeah. So anyway, that's just an aside, some recommendations.
I have an issue with people who have people coming in to clean your home as well.
Oh, yes, my housekeeper,
Yeah.
annually, I get a new, not just the certificate of liability Accord form that you can download off the internet or get from the broker. I get their actual Accord from the carrier, signed, documented, just from my housekeeper. Why? Because we're, as Barry said, to a higher standard, and we're just like the Sixth Sense. He saw dead people, we see comp claims.
I just pay cash and deny I know anybody.
Auga, auga, auga.
They've
That's
never been in my
not.
house
You hear that? All right. Kyle Pike, I'm going to go over relatively quickly. I just want you to know something. In the state of California, this is the next slide, page 28, slide 28, number 28. In the state of California, for temporary disability purposes, status post SB 899 in 2005 and 863 as of January 1, 2013, every employee has a bucket of temporary disability not to exceed 104 weeks. That's 2 years, okay? That 2 years has to be paid within 5 years of the date of injury. This case turns that on its head, but part of it is because this employee, the injured worker, was of a special character. He was a deputy sheriff. Okay, as Barry told you, they have presumptions, they have special things given to them because they put their lives in danger for us every day. Okay, so let's say from that standpoint, maybe he gets a benefit that the rest of us wouldn't get. Okay, so in this particular case, he had a claim in 2010, he settled it in 2011, he brought a timely petition for new and further disability in 2015, 5 years. Temporary disability, but that 5 years, the 5 years from the date of injury ran July of 2015. So up until this case, we would say, yes, you can have all kinds of more treatment. You might be temporarily totally disabled, but if we hadn't paid you your 2 years, 104 weeks of benefits, we would say, you, Mr. Sheriff, don't get any more benefits because the 5 years has lapsed as far as temporary disability is concerned. But for permanent partial disability, we might give you some more benefits down the line when this new issue has been dealt with, your surgery and things like that. And his attorney went to court and said, no, this was timely filed, and his disability started to arise within the 5 years, and he hasn't been paid with his 104 weeks. Therefore, we get more temporary disability benefits. And the court said, yes, because it was timely filed and the disability arose before the 5 years elapsed and you hadn't already paid 104 weeks, you're going to pay continuously until the 104 weeks is actually paid out. So in my mind, it puts the statute of 5 years on its head for benefits of 2 years of benefits within 5 years. Doesn't matter as long as they're still disabled before the 5 years runs and that you haven't paid the 104 weeks. It's a rare case because firefighters and cops go back to work in between their injuries and their acute care, whereas many employees won't. They'll just take the 2 years off in the beginning of the case. Okay?
So this is a test question that I'll require somebody that I select from the audience to answer. Anybody have any employees that travel outside the country?
Good.
Okay, well, let's say they travel kind of outside the country and they go to Wisconsin.
That's a different country than me.
Anybody have, okay, so let's say that we require, as the employer, we require our employee to travel to Wisconsin, and while in Wisconsin, our employee goes to a strip club and meets up with someone, goes back to that person's, to his hotel with that person, is engaging in activities that we might only just imagine, and he dies of a heart attack. This is a real case, by the way. Is that work-related?
Yes.
Okay. So the issue there is, let's break it down and let's say certainly the employee was required to travel to this location as part of their work. Question is whether or not the events that took place in the bed are events that are work-related or not. So I guess we could say that that's not work-related, except for in California we have something called the personal comfort doctrine, which says that if you're engaging in personal comfort, then that's work-related. Now, would it make a difference if it was a prostitute versus somebody that he just picked up at the bar? One might argue that prostitution is illegal in Wisconsin, that they're engaged in a criminal activity, and therefore that would not be work-related because engaging in a criminal activity is not work-related. So the reason I asked the question, of course, is that there is a case, and the case basically says that would be a compensable injury unless you're able to establish, as I said to you earlier, that 100% of the reason why the person died was because of non-industrial factors. The fact of the matter is that the 1% in that particular case could be the elevated heart rate of somebody who is engaged in that kind of activity, and if all it requires is 1%, that's going to be a work-related injury. By the way, for those of you who haven't heard of the personal comfort doctrine, it started with a case that in the old days when people would take breaks, they would be smoking cigarettes, and usually they'd go into the restroom, they'd sit on the toilet, smoke a cigarette while they're on their breaks, and this one particular gentleman was smoking a cigarette and threw the cigarette into the toilet before he got up, but the toilet had not been flushed the night before with all the chemicals in it, and there was a flash fire while he was sitting on the toilet. And the cases, yes, not a pleasant thing. The cases have since held that those events were for his personal comfort. He was on a break. He was on the employer's premises. Wasn't doing anything illegal at that point in time. And that was found to be work-related. So all these personal comfort issues have extended. And I only bring that to your attention because a couple of you looked like you were falling asleep. So. And I won't go into how self-gratification at work is also work-related. I won't go into that today, but if
He
anybody
means
ever,
eating chocolates.
yeah, if anybody ever wants to know about those cases, I can tell you about
Person
those.
for Marsh, she used her own car for business. She had been on sales calls all day. She was between her sales call, we'll call that, was her yoga studio and a yogurt shop. On her way home, she stopped and went to yoga, I think, so she could have the yogurt. And got into a car accident after the yogurt on her way to her home, but still on the continuum between her last sales call and her home. Of course, defendant denied that case, saying, this is a material deviation, right? Why is going to yogurt and yoga any benefit to the employer? It's a deviation from her employment. Because if she'd gone from her last call to her home, that wouldn't have been commute, right? Because that's not her normal location of work. That was a sales call. So that would have been actual work until she got to her home. And the court said, no, that's although that is a deviation, she was along the continuum of the commute from the sales call to her home, which would have been covered. Now, if yoga was behind the sales call and she had to backtrack, I think the facts start to change. But material deviations are a problem. That's why you need to know where your employees are. But if you pay for their car, you give them a car allowance, or you mandate that they use their car for your work, that's the other thing that the Marsh case talked about.
How about if we have two buildings and the employee drives his personal vehicle to the other building and we're not paying him, are we supposed to be paying him mileage? Is that-
Explain to me, I need a little bit more information. So the employee comes to work to building A in the morning?
Yes.
And then you require him to go to building B?
Yes.
You're supposed to be paying him during that time period.
We are paying him.
Okay, so then if you're paying him during that time period, my guess is it's going to be considered work-related. We might come up with a different defense to that, but if you're paying him and he was receiving earnings for which you are paying workers' compensation coverage through payroll, it's most likely going to be a covered claim.
Even though we're not paying him mileage.
Yeah.
Yes.
Mileage wouldn't matter.
That wouldn't matter in that particular scenario. In this particular, and he's not mandated to use his car for you. If the buildings were close enough together and you had a golf cart, it would still be covered. Okay? But in her case, they mandated she use her car for their sales
One
calls.
moment.
Yes, at the end.
Most of the time, a work-related injury is cheaper than if you get sued civilly.
Sure.
So you would maybe rather have the protection of being the employer with workers' compensation for those kinds of injuries than getting yourself sued somehow. And again, these injuries are few and far between. A waiver does you no good, but I will tell you there are employers that say once you've clocked out, you are obligated to leave the premises. We have that all the time, mostly for security reasons. But I had a death case, so here's this death case that I had about 4 years ago. Guy clocked out of work at a local grocery market, went into the loading dock of the grocery market, was smoking a cigarette, and somebody came up and shot him in the head and killed him. So here we have an employee that was off the clock, engaging in a personal activity. It turns out that he was meeting friends there. He said, meet me there after work, and he was waiting for them to get off work. And we had a guy, we had no idea why he got shot. So we had all of these factors, but I have to tell you, again, especially in death cases, it wasn't illegal for him to be sitting there. He wasn't doing anything illegal, although we did try to argue that it was a gang-related shooting because he had a gang tattoo and all that other stuff. So even that case, you know, could have been, if we didn't settle it, found to be work-related. On the other hand, I wouldn't want that employee to be allowed to sue us for failure to provide security at the loading dock.
Right,
Because the
that's-
death case is worth, in a civil court, is worth a whole lot more than the statutory workers' comp death benefits.
So it's better to settle on workers' comp side than to have it be a liability.
Absolutely.
Yes.
Absolutely.
Yes.
Absolutely.
Beginning January 1st of 2013, they changed the law on psychiatric cases related to work. So you might recall that there were CT stress cases being filed left and right. And as soon as somebody would leave work, they'd file a continuous trauma stress case. And here we were spending all kinds of money, you know, for that. So they passed a law effective January 1st, 2013 that said you cannot get additional permanent disability for sexual dysfunction, sleep dysfunction, or a psychiatric disorder,
Slide
that
32.
arises out of a work-related injury. So no more CTs, no more claims for stress related to your specific injury. In other words, no add-ons. So if you had an orthopedic injury, couldn't just necessarily add on a CT stress, a psych component to it. There is one exception to that, and I want to read the exception so you'll know, because it becomes important in the Torres case. An exception is being a victim of a violent act or direct exposure to a significant violent act. Okay, so here's what any reasonable minds here would think that means, is that if somebody is a victim of a violent crime while they're at work and they get hurt, they can have a psychiatric component of it. That's what that, does that make sense? I don't think any of us have too much trouble with it. We understand what the suggestion was and why that was. Now we have California workers' compensation. So in this particular case, Mr. Torres was a tree trimmer, and he was up in trimming trees when he fell after a branch broke, and as he's falling, the helmet flies off, and then he lands on his head. He actually stopped halfway down, the helmet goes off, and then he falls the rest of the way down, hitting his head. So why is that? Okay, so no question it's work-related. The question was, can he have a psychiatric component out of that? Because after all, does this meet any one of the exceptions? Well, the argument that was made in that particular case was that this falling from the tree was a significant violent act. Now, if you look again, what I said was being a victim of a violent act or direct exposure to a significant violent act, we all thought, I thought, we were talking about a crime of some sort. And in this particular case, the workers' compensation judge said, yeah, this wasn't a violent act or a violent crime within the meaning of the labor code, and didn't give him any psychiatric disability for it. Well, they filed a petition for reconsideration and appealed to the Workers' Compensation Appeals Board level. And the question was, is falling 20 feet from a tree considered a, quote, violent act? And again, all of us reasonable people in this room would say, no, it's not a crime, it's nothing like that. The legislature didn't intend for that to happen, and our lovely Workers' Compensation Appeals Board said, there's nowhere in that section that violent act means a criminal act. And if a tree trimmer falls 20 feet, that's a violent act. And he got psychiatric benefits in that case. So again, the pendulum is starting to swing back the other way. We had this great statute which prevented all kinds of psychiatric complaints and compensable permanent disability, and now it's starting to shift back the other way, yes.
So Madsen is at slide 48. It's also a violent act case, but in this case, I don't know if any of you have ever been up my way and taken the 154 through the beautiful area of San Luis Obispo, but this was a Saticoy lemon truck driver. He was involved in a big rig accident on that 154 freeway, which is basically a 2-lane road that does not have very much traffic on it except for trucks. And it was a single collision. I think he probably started to fall asleep at the wheel and jackknifed. And he was stuck in the vehicle for quite a long amount of time, 35 to 40 minutes. And he was not only stuck in the vehicle, but the vehicle was leaking gasoline, and he thought he was going to die. And so whether the applicant's emotional and psychiatric injury arose from a violent act pursuant to the exception of Labor Code Section 4661.C2, and the court said the fact that he had to wait 30 to 45 minutes, 30 to 40 minutes, the jaws of life had to be used. Under these circumstances, the applicant's injury can be characterized as resulting from extreme or intense force and was vehemently threatening. Applicant's mechanism of injury constitutes a violent act within the definition of 3208.3b, and therefore permanent disability from it, the post-traumatic stress syndrome that arose from that accident was found to be compensable, and he received permanent disability for psychiatric purposes. Make sure you understand that although you can't get permanent disability for these kinds of acts, sudden, extraordinary, and violent, unless they are these things, sexual dysfunction, and sleep, an injured worker could still get temporary disability and medical treatment for those things. So, even if it hadn't been a violent act, the injured worker could have gotten psychiatric treatment for his post-traumatic stress disorder and temporary disability. We wanted to limit permanent disability. And the applicant's bar said, no, we're going to make this novel argument, and they won. Jackson, you want to do Jackson?
Yeah.
Jackson's at 52.
Okay, so this is the one I talked about, the Rice case, that they have the legislation that could come up. It involves a police officer, so be aware of that right away. There's going to be a tendency to want to favor the injured employee. This was a 29-year-old police officer. He was not on the police department for a long time. That becomes very important. He developed a neck pain and needed surgery. He went to the doctor, and to make a long story short, he had treatment for the neck, and then ultimately he went to a doctor to evaluate his permanent disability. The doctor said the following: to a reasonable degree of medical probability, genetics has played a role in Mr. Rice's injury, despite the fact there was no way to test for genetic factors of this. That is, what they were saying was that the cervical spine disease, the way it looked objectively, the cervical spine disease, was at least in part caused by the pre-existing genetic disposition for the employee to get neck problems. The doctor cited a whole bunch of reports. They had studies about the father and the grandfather of the patient who also had neck problems and all that other stuff. And they basically said, we're going to apportion a significant sum to the fact that you have a pre-existing propensity from a genetic standpoint to get a condition. Now, in the old days, of course, that would be irrelevant, because in the old days, we were the straw that broke the camel's back. But now, this doctor, with a whole bunch of studies to support her decision, basically said that you were born with an apportioning factor, your genes, your genetics. And even though we don't have any objective evidence to test that you have anything related to that genetic predisposition, we're going to apportion that out, and you're not going to get that from the employer. Well, this was obviously a pretty significant case, and even those of us who are very defense mind oriented said to ourselves, well, how does this make a lot of sense? That would mean that if somebody's had it, the grandfather had it, etc., and then the employee has a work-related injury, and somehow there's a heart component to it, that they're going to presume that just because father and grandfather had it, that it was genetic, and that employee is not going to collect all the benefits that they're entitled to get in workers' compensation. What we believed should have happened in this case, even though we really love this case now, except for there's a bill that's going to perhaps overturn it, what really we should have said is that if the person has a pre-existing genetic condition and it has manifested itself somehow that we can objectively identify it, like in his neck, we can see a 29-year-old with pre-existing degenerative disc disease in the neck. Most 29-year-olds don't have that. But if he was 29 and he had all of this objective evidence of degenerative disc disease in his neck, then that should be apportioned. That's where that case should have gone, but it didn't. It went all the way and said, we don't care if you don't find the degenerative disc disease. We're just going to assume, because Daddy and Grandpa had it, that part of your neck condition was genetic in nature. And that's the Rice case, and that's the case that the bill is introduced to try to overturn this case. And even our office has written an article saying that reasonable minds should say that just because somebody has a gene defect, it doesn't mean they're ever going to get anything. And I'll tell you a personal story now. I have a brother, I have two brothers, and both of my brothers and I all have an ATM gene mutation. The ATM gene mutation causes an increased likelihood that you're going to get pancreatic cancer. And my older brother has pancreatic cancer. He's had it for 3 years. My little brother and I don't have pancreatic cancer, and we may never get pancreatic cancer. So just because we have the mutation doesn't mean the mutation is going to result in anything happening. Now, that's why it's unusual. Now, if I were to have developed pancreatitis, which they know also comes from the ATM, well then now you've got an issue that I actually have symptoms from it. But without any objective evidence of it, it's just a mutated gene, and all of us have some sort of mutations in our system. But as we are cracking the human genome, I heard this speech from a geneticist the other day, When they used to do crack the human genome at UCLA, it took 3 days, and their entire storage capacity at UCLA to set forth all of the genetic markers that one individual had. That's how it used to be. Now, they can do it in 3 minutes, and they have, it's in the cloud somewhere. So as they start to crack all of our human genomes, we are all going to have mutations. And the argument is going to be that just because we have a genetic mutation, it doesn't mean anything is going to happen. So why should the employee be denied permanent disability because they have just a genetic mutation? Whereas if they have a genetic mutation and they get degenerative disc disease, then we understand that. And that's the distinction. But this is one of 2 or 3 hotbed potatoes that we're going to see the next year.
Gosh, I mean, it just seems like the road forward is, all right, so many people have parents who have had heart conditions. Every time somebody has something heart-related at work, well, then you have family who've had heart conditions.
Well, so look, and what have you learned today? When would it be irrelevant what existed previously if only 1% of it is work-related and the person dies?
Yeah.
So that's why we all of the time see death cases as being much more easy to establish than other work-related claims. So that's the Rice case, and we'll have to deal with that. We got 10 more minutes.
Hikita, you want to do Hikita?
Sure, why not?
Hikita is at slide 66. We're moving around because we want to make sure you get a flavor for all of the things we're talking about. And Hikita is also a groundbreaking case.
Okay, so first I need to tell you this. There is a big recent trend in the big expenses in a California workers' compensation case is not the permanent disability that the employee suffers, but rather the medical treatment that is incurred as a result of the employee having sustained a work-related injury. We have in our office 2 cases, very, very similar set of circumstances, and I'll relay them really quickly. One of them just came in a couple of days ago, and the person had a neck injury at work. They do neck surgery. While they are doing neck surgery, they find a malignant tumor on the person's cervical spine. Okay? And that, if that's not taken care of somehow, that person's going to have a malignant tumor and perhaps die. So they don't take the malignant tumor out there right away because all they're really doing is treating the cervical spine orthopedic injury. They close the person up, they wake the person up, and they say, oh, well, we got good and bad news. The good news is your neck's going to be fine from an orthopedic standpoint. The bad news is you're going to die from a malignant tumor on your neck that we found. So in that particular case, a report has now been generated that basically says we can't provide additional orthopedic treatment to that employee until we take care of the malignant tumor that's in the person's neck. And not only that, but let's say we go in and we take it out. Once we take it out, then we have to treat the cancer, because if we don't treat the cancer, the work-related injury is going to be worse. And they are now demanding all the cancer treatment to be provided on an industrial basis. And this is the second case we have like that in our office. We don't need to go through the Hikita case. Just be aware of the fact that these things are that pendulum swinging back the other way. And the applicant's bar is looking, and believe me when I tell you that most of them don't care whether you take care of that person's malignant tumor or not. They only care about the money that they get from the workers' compensation case, most of them. So if they can build up the potential exposure for future medical treatment, i.e. paying for this cancer treatment, their fee is going to go up. What do you want to cover? I got 5 minutes.
I have 5 minutes. I really just think we should.
Can I cover what I want on the fee house stuff?
Let's go to lie.
No, I want to go, let me do the fee house stuff.
The fee, and then you'll do lie, okay. I'll do
So,
lie.
so I told you I was going to try to spend a few minutes to talk to you and have you wake up and take something away from today, and so I'm going to try to do that. There are 3 ways to resolve a workers' compensation case. You try the workers' compensation case, you stipulate to the workers' comp case, or you resolve it by way of compromise and release. Have you all seen this form? This is called a compromise and release. If you've seen it before, it basically settles everything in your workers' compensation case. And when you settle everything, you're settling everything that is related to that work-related injury. Everything within the jurisdiction of the Workers' Compensation Appeals Board. So when your carrier prepares one of these, they prepare this state form and they settle those things pending before the Workers' Compensation Appeals Board of the state of California. You, on the other hand, as the employer, are faced with, perhaps, an overlying FEHA, ADA, etc. type claim. So here's the scenario. It's a continuous trauma stress case or a skin and content case that's filed before the Workers' Compensation Appeals Board alleging harassment from the employer, sexual abuse, all kinds of stuff like that. And that gets filed in a workers' comp case, and you turn it over to your workers' comp carrier. The workers' compensation attorney for the injured worker, who doesn't do civil stuff, sends it off to Attorney Feelgood, and Attorney Feelgood handles the FEHA case, and the next thing you know, you're getting a letter saying, starts off with, send me your personnel file. I want to see all the bad things you've done to my client. And then you might get, like I got yesterday, a letter on one of these cases that says, please send me $2 million and we can resolve the issue now. And I've started to write a check out, and I changed my mind, so I'm not going to write a check out. Anyway, so you've got these 2 cases that are running concurrently. The workers' comp carrier wants to settle their case because, as most of you have, it's guaranteed cost policy. It's all their money. They're going to turn around and kick in the back of the head by increasing your premium, but it's their money. They want to settle the case quickly. So they settle the case quickly. And if you settle the case with this standard form here, compromise and release, and everybody signs it, and the Workers' Compensation Appeals Board approves it, because every settlement has to be approved by the Workers' Compensation Appeals Board, you have settled your workers' compensation case. You have not settled anything else arising out of the same set of facts that were alleged in the workers' compensation case, and now you're straddled with a FEHA claim for which you probably don't have workers' employment law coverage. Maybe you have some, but not what you need. So, we, in our firm, have always done an addendum to the compromise and release. It's our own addendum. This is kind of what it looks like. And up until last month, we never put in there any language about FEHA and all that other stuff because most of the workers' compensation judges would cross it out and say, hey, that's not our venue. And most of the injured workers' attorneys say, hey, I'm not an employment law lawyer, I'm an applicant's workers' comp lawyer, and they would cross it out. And for the most part, that's what would happen. And then 2 cases came down just within the last couple of months. The first one says, ladies and gentlemen, this form, as it exists on the State of California website, does not settle any FEHA claims. So that's what we know from the form. In that case, they said, though, it doesn't contain any language which would settle FEHA. And it doesn't. It's a workers' comp form. Literally, 2 weeks later, another case comes out. And in that particular case, the following language exists. We are settling any and all claims under FEHA, ADA, including claims of wrongful termination, sexual harassment, racial discrimination, and one of those big general release language information. And we thought, okay, the court's going to say that's not within the venue of the Workers' Compensation Appeals Board, and we're not going to let you do that. Instead, the court said, oh yeah, that settles FEHA. Settles ADA, settles everything in there that's in that. This is a contract. You, applicant's attorney, are a lawyer. You are charged with knowing what you're settling, and therefore, you had actual knowledge that FEHA language was in there. You didn't cross it out, and you signed it. And we know it was before the Workers' Compensation Appeals Board, and they don't have jurisdiction. But what we have is a contract, a written contract, that says FEHA can be settled. Both of these cases tell us that we can settle FEHA in a California workers' compensation case now, which is hallelujah. So we have amended our addendum, and our addendum now says, this compromise and release includes resolution of all claims arising under state and federal law regulations, including California Fair Employment and Housing Act, federal and state wage and hour law, federal and state false claims act, Title IV of the Civil Rights Act, the American with Disabilities Act, the Family Medical Leave Act, the California Family Medical Right Act, ... I'm not going to go through it all. That now is in our addendum, in our compromise and release. And if you can get cooperation from your carrier to do this, imagine how much you are saving on the back end. So all I'm saying is consider it if you have a strong relationship with your carrier, especially if you know that this is a troublemaker employee and this is coming down the pike. Do it and use the carrier's money to do it. Yes.
So then, if they agree to that, then that would handle any like wage and hour claims that could come out later? I mean,
That's what we would say.
Well, we know FEHA is covered because that's what they
Right.
put in there. Whether or not, and from my standpoint, if what triggered FEHA being covered was the employee and his attorney knowing the language was in there, why not all of this stuff? Now, we don't have any cases on it, and it's one of the arguments that was not made that should have been made if I was the injured worker's attorney was, wait a second, to settle that stuff, there has to be consideration. To have a general release, there has to be money. Show me the money for that language. And then you'd have to show that you paid more than the value of the underlying workers' comp case to get that language. But right now, we are just happy as we could possibly be with these two cases.
And we do have some employers who do have insurance, who do require general releases, and they will pay for them, $100, $200, up to $300. And then maybe even more, but you have to go back to them on an individual basis. But that's the extent of authority to their claims administrator when we do these kinds of things. And if there's consideration, it's even better.
So here,
Do lie? No?
not yet. Let me do one thing. So here's the answer your carrier is going to give you, so be aware of it. We don't cover in our workers' compensation policies these things. Therefore, we can't settle these things. That's what they will tell you. And I would then turn them to page 7 of the compromise and release, where they always check the box, Labor Code Section 132A and serious and willful misconduct cases. Those are not covered under their policies either, and guess what? They settle them all the time. So don't let them give you that language that would preclude you from resolving the FEHA claims. I know we're out of time.
Montage Insurance. Our mission is to further your mission with dedication, service, and integrity while protecting your assets and giving back to our community.